The ranch was quiet that morning. Too quiet for the season. I was checking fence lines near the north pasture when I heard it, a single sharp crack that didn't belong to the land. Not a gate. Not machinery. Not thunder. A rifle shot. It came from the direction of the upper grazing field. That field was locked. Posted. Clearly marked. No hunting. No exceptions. It had been that way for years, and everyone knew why. The bull. He wasn't aggressive. He wasn't showy. He was valuable because he was steady. Proven bloodline. Strong genetics. Calm temperament. The kind of animal you don't replace, you build a program around. $50,000 worth of work and patience. I took off running. By the time I reached the rise overlooking the pasture, I already knew. Animals react before people do. The rest of the herd had scattered, clustered near the far fence, restless and confused. And in the center of the field, he was down. No movement. No struggle. Just still. I stood there longer than I should have. Long enough for anger to show up late, after disbelief finished its turn. There were footprints, tire tracks, shell casings, hunters. On my land. I called the sheriff first. Not the HOA. Not neighbors. The sheriff. While I waited, I checked the gates. They were open. Every one of them. That's when the memory clicked into place. The email from the HOA president weeks earlier. Karen. Framed as a community courtesy. She'd asked if I would consider allowing seasonal access for local hunters to reduce wildlife near the development. I'd said no. Clear. Written. Documented. She'd replied with something vague about community safety and share responsibility. I didn't respond again. Apparently she had. The deputies arrived. They documented the scene. Confirmed the shot. Confirmed the bull's value. Confirmed the gates hadn't been forced. One of them asked the obvious question. Who had permission to be here? No one, I said. Then a neighbor pulled up. He didn't look surprised. He said he'd seen Karen earlier that morning, standing near the access road, talking to two men in camo. He assumed it was authorized, because she told them it was. She told them the land was open for controlled hunting, that the HOA had approved it, that everything was cleared. None of it was true. The hunters were detained, confused more than defiant. They showed messages on their phones, directions, times, even a marked map. Sent by Karen. She hadn't just ignored my answer. She'd overridden it. The bull was declared a loss before noon. $50,000. Gone. And that was just the number on paper. What Karen didn't understand was that this wasn't a dispute over access. This was negligence. This was misrepresentation. This was criminal. And for the first time since she'd started treating my land like a community resource, the consequences weren't theoretical anymore. They were lying in the grass. The deputies didn't let the hunters leave right away. Not because they were aggressive. Because nothing about their story lined up with the law. They showed messages on their phones. Screenshots. Maps. A time window. Even instructions on which gate to use and which areas to avoid. All sent from the same number. Karen's. She told them the land was HOA-managed open range. That livestock had been moved. That the bull wasn't supposed to be there. Every sentence was false. The deputies photographed the messages, logged the shell casings, and took statements. The hunters were cited for unlawful discharge and trespass, but even they knew this wasn't going to stop with them. One of them said it out loud. She said she was the authority. That word again. Authority. By afternoon, the ranch had turned into a case file. Wildlife officers arrived next. They confirmed the bull's registration, breeding valuation, and replacement cost. They documented the loss not as a hunting incident, but as destruction of livestock. That changed everything. Livestock isn't wildlife. It isn't game. It's property. And in this case, it was high-value property. I pulled every message I'd ever received from Karen. Every refusal. Every boundary notice. Every sign installation record. I didn't need to explain intent. The timeline did that for me. She asked. I refused. She proceeded anyway. The HOA board was notified by the sheriff before I contacted them. That wasn't my choice. That was protocol. Karen didn't respond to calls. By evening, the board issued a statement saying they were unaware of any hunting authorization and that any action taken by individuals did not reflect HOA policy. The deputies read it, then asked a question. Who is the HOA president? When I answered, they nodded and wrote it down. They explained something important. Even if Karen believed she had authority, which she didn't, representing herself as a landowner or property manager to grant access carries liability, especially when it results in loss, especially when there's written proof. The hunters were released later that night. Not cleared, just no longer detained. Their cooperation mattered. They'd been the sled and the evidence showed it. Karen, on the other hand, had gone silent. That silence didn't last. Because when someone lets armed strangers onto private land and valuable livestock is killed, it stops being an HOA issue. It becomes a legal one. And the direction it was heading was no longer something she could manage with emails or excuses. Karen resurfaced 2 days later. Not at the ranch. Not at a board meeting. Through a lawyer. The letter was careful with its words. It expressed regret for the incident, without admitting fault. It suggested the hunters may have misunderstood the scope of access. It implied the bull's value was subject to review. That last part told me everything. They were preparing to argue numbers instead of responsibility. My attorney responded the same afternoon.
Short. Direct.
Attached were the deputies' reports, wildlife officer assessments, valuation records, and screenshots of Karen's messages authorizing access. The response also included something the HOA hadn't accounted for. Insurance. HOA liability policies don't like firearms. They don't like livestock loss. They definitely don't like board members granting access to land they don't own. The insurer requested a statement from Karen. She declined. That refusal triggered the next step automatically. The insurer appointed independent counsel, which meant Karen was no longer speaking for the HOA, she was speaking about herself. At the same time, the board started fracturing. One member contacted me privately to ask for copies of the messages. Another asked whether Karen had ever shown them proof of authority over my land. She hadn't, because there was none. Wildlife Enforcement completed their report and forwarded it to the county prosecutor's office. No charges yet, but the language was firm. Unauthorized hunting access. Misrepresentation. Property loss. Karen finally called me that night. Her voice wasn't confident anymore. She said it was an honest mistake. That she believed the land fell under HOA jurisdiction. That she was trying to help the community. I asked her a single question. Did you read my refusal? She didn't answer. Because answering meant admitting she ignored it. I told her to direct all further communication to my attorney.
She did.
By the end of the week, the HOA board held an emergency session without her. Residents attended. Hunters' names were circulating. The value of the bull was being discussed openly. $50,000 had a way of sharpening attention. Someone asked whether the HOA would be responsible for replacing the animal. The board didn't answer, because they were waiting on the insurer. And the insurer was deciding whether this was a policy claim or a personal one. The emergency board meeting didn't last long. Not because there wasn't anything to discuss, but because there was too much. Karen wasn't present. Her attorney advised her not to attend. That alone told the board everything they needed to know. When someone avoids the room where facts are being laid out, it's usually because those facts don't bend. The insurer's representative joined by phone. He didn't soften his words. He explained that the HOA's policy did not cover intentional authorization of access to non-HOA property, especially when that authorization involved firearms and resulted in loss of livestock. The policy also excluded coverage when a board member acted outside their defined role. Then, he said the sentence Karen never expected anyone to say out loud. This may be a personal liability matter. The room went quiet. Someone asked what that meant. It meant the HOA wasn't paying for the bull. It meant the rebuild, the settlement, the damages, if any, would not come out of community funds. It meant Karen. The board immediately voted to suspend her authority pending investigation. Not because they suddenly cared about my land, but because they needed distance.
Fast.
The county prosecutor's office requested additional documentation that same afternoon. Not charges yet, but they wanted clarity on whether Karen knowingly misrepresented ownership to armed individuals. That distinction mattered. Ignorance is one thing. Contradiction is another. And there it was in writing. My refusal. Her authorization. The timestamps. By the end of the day, Karen's attorney reached out again. This time, the tone had changed. They proposed restitution. Not discussion. Not debate. Restitution. They acknowledged the bull's value. Asked for confirmation of the breeding records. Requested a timeline for replacement. They asked whether a financial settlement would resolve the matter, without further escalation. My answer was simple. This wasn't just about money. I wanted formal acknowledgement, written responsibility, and permanent restrictions preventing the HOA or any representative from granting access to my land again. The sheriff supported it. Wildlife enforcement supported it. The board didn't argue, because everyone understood the alternative. Karen stepping down became official the following morning. No announcement. No explanation. Just a quiet update on the HOA website. Residents noticed anyway. And so did the hunters. One of them reached out to apologize. He said he'd trusted what he was told. That he never would have taken the shot if he'd known the bull was livestock. I believed him. Because the real issue wasn't the trigger. It was the permission. And that permission never existed. By the time the sun set that night, the pasture was quiet again. Gates closed. Signs intact. The herd settled. But something fundamental had shifted. The HOA had learned a lesson they couldn't undo. And Karen had learned that authority doesn't come from a title. It comes from truth. The settlement didn't take long. Once liability was acknowledged, there wasn't much left to negotiate. The valuation stood. The records were clear. The payment covered the bull's full assessed value, plus associated losses tied to the breeding program he anchored. On paper, it was resolved. On the land, it never fully would be. You don't replace an animal like that by writing a check. Genetics take years. Temperament takes patience. Trust between animals and the people who work them can't be rushed. The money went where it needed to go. New bloodlines were sourced. Plans adjusted. The ranch kept moving forward. But the pasture where the bull fell stayed quiet for a long time. Karen never contacted me again. Her resignation became permanent. Not a suspension. Not a leave. She was removed from the board entirely after a formal vote. The HOA issued a written acknowledgement stating that my land was not under its authority and that no representative would ever again claim access or grant permission on behalf of the association. It was signed, recorded, filed. The gates stayed locked. The signs stayed up. And no one challenged them. The hunter's case was closed quietly. Citations stood, but no further action was taken. The authorities recognized what the evidence showed. They'd been misled. They paid their fines and walked away knowing better. So did the neighborhood. The HOA stopped talking about shared responsibility. Stopped blurring lines. Stopped assuming that proximity meant permission. Because the cost of that assumption was no longer abstract. It had a number, a report, and a record. Every so often, someone asks why I didn't push harder. Why I didn't sue for more. Why I didn't make it public. The answer is simple. The point wasn't to punish. It was to stop it from ever happening again. And that worked. The land returned to its rhythm. The herd adjusted. New stock took time to settle, but eventually the balance returned. What didn't return was the illusion of control the HOA once had. They learned, permanently, that my ranch wasn't a convenience, a buffer, or a solution to their problems. It was mine. And now, everyone understood that the hard way.